Mr. President, it has been a long debate lasting 4 days so far, and the tempers have become understandably frayed in that time. I should just like to begin by, I have not been here as well, Mr. President, so that I was able to follow some of the debate from distance. Now, as I understand it, and I have to ask the forgiveness of the Senate for disregarding in large part the contributions of Senator Boodoo, Senator John Bates, Senator Cummins, Senator Roberts Rajman, and my good friend Senator Brown, who I don't mean to insult them, but I don't think that they added much to the substance of the debate. Now, I left Senator Arawi, of course, for last, because I'll begin with him. But before I get there, I just want to sketch the issues which reared their heads over the past 4 days. There was some discussion about a sunset clause. There was some discussion about clarifying and limiting the Prime Minister's powers. There was some discussion about possibly shorter time frames for zones. Also, extraordinary powers were said to be justifiable only by clear, transparent, and defensible criteria exercised with strong safeguards, oversight, and accountability, and implemented in a way that avoids stigmatizing entire communities. There was as well some commentary on the declaration of a zone, what is meant by threats to the rule of law, rampant criminality, etc. There was some suggestion with respect to enhanced reporting, strengthening parliamentary oversight, body-worn cameras, and the Social Transformation Committee. Now, I return to all of them in the course of what I propose to say shortly. If I could just, by way of introduction as well, say that in the course of the past 4 days, we have had a bill with 28 clauses, a bill that was drafted by my friends opposite, modeled on the Jamaican zones legislation in 2017, authored by Senator Arawi, still visible on the website of the Trinidad and Tobago Law Association, all of the correspondence from the Prime Minister to the Law Association, from the Prime Minister to this one, and so on and so forth. The impression that has been created is that, one, the Honourable Prime Minister is a dictator, that this legislation is new in some way, that, and I have to say that this, before anyone jumps up on a point of order, this has to be the height of dishonesty. For you to draft a bill, for you to claim the bill, for you to sell the bill, and then for you to come to this house and pretend that you know nothing of the legislation. The legislation is legislation of the big bad UNC and the big bad Honourable Prime Minister. That is the height of dishonesty. Now, in those 28 clauses, I have counted 50, close to 50, it may be 48, close to 50 proposed amendments. And I propose to outline the government's position on this matter at the end of my winding up. And those 50 came by way of 22 separate proposals. Some amendments then amended themselves. And it is mind-boggling. And in the Office of the Attorney General, we have staff who have been in place for quite some time. So the author of the legislation in 2017 happens to be the author of the legislation today. And he is not too far away in Cabildo House, looking at the proceedings and in a state of bewilderment as to what is going on. Nevertheless, Mr. President, I will attempt to do the best that I can by him, by the public servants who have worked on this measure, and by the people of the Republic of Trinidad and Tobago. Now, I believe it was Senator McNeish who noted that no other strategy has yielded significant nor comparable results in suppressing gang-related homicide and serious crime rates as the state of emergency. He went on to say, however, that continuous states of emergency over an indefinite period of time, while they may effectively suppress crime, cannot be a tenable solution. We on this side are fully cognizant of that, as my colleagues on the other side, when they wore different hats, were. Now, the fact is that this state of emergency, which ends in 4 days' time, was not called, was not declared to deal with gang activity. And that is different from what my friends on the other side did. In December, and they like to speak of what happens on Christmas Eve and who is the Grinch of Christmas and so on and so forth. On December the 30th, 2024, the nation awoke to the declaration of a state of emergency. Not by the Prime Minister, who was sipping a glass. There's a camera everywhere now. He was sipping a glass in Tobago. That is fact. Not by him. I don't know what was in the glass. I would not get to that. He was partying in Tobago. The state of emergency was declared by the younger one. That's all I will say. And it was declared for the express purpose of dealing with what? Gang-related reprisal crime. That is it. Gang-related reprisal crime. That went on until a week or two before the general election, believe it or not. That state of emergency, it was renewed 14 days after. It went on until 2 weeks or so before a general election. an act of greater suicide, I do not know. They went into a general election in a state of emergency and have the temerity to come this afternoon to tell us about what is democratic and what is not democratic. Mr. President, gang-related homicide is a serious thing in this country. As a matter of fact, the former leader of my colleagues declared it a national health emergency. Public health, I stand corrected. Now, in July of 2025, heads of government, and my friend Senator Brown would know of this, were sufficiently alarmed at this to say that, and I quote, "The scourge of gun crime and violence across the Caribbean region, driven by the proliferation of illegal firearms and the activities of what? Gangs and other organized criminal groups continue to pose a serious threat to the region." Now, heads are talking there primarily about three countries. Haiti, in which the gangs have overwhelmed the government. Jamaica, in which our colleagues have taken appropriate steps to prevent exactly that, and Trinidad and Tobago. And they went on. They said, gang-related crime continues to pose a serious threat to the region. Its institutions of governance, that's not my words, its institutions of governance and the very fabric of our societies. Now, that was in July of 2025 in Montego Bay. Now, I want us to pause for a second, because what heads were saying was that they were aware of the developments in Haiti, aware of the developments in Jamaica, aware of the developments in Trinidad and Tobago, and that they viewed those developments as existential threats to governance, gangs ruling society. Jamaica and Trinidad and Tobago permitted themselves to express deep concern. That is in the wording of the communique. And, Mr. President, you have been around long enough to know that that is diplomatic speak for panic. In my piloting of the bill, I read from a report of the Trinidad and Tobago Police Service, and I heard my friend Senator Brown saying that, well, there's no data. I read from reports of the TTPS. And those reports clearly identified that gang-related, serious gang-related crime, murders in particular, demonstrate, I don't know how more data-driven you could get than this, historical geographic concentrations in Trinidad and Tobago. They went on to say, this is the TTPS, not the PNM party group, not the UNC, the TTPS. They said national statistics are heavily skewed by criminal activity in these areas. And they went on to say that nationwide interventions, like the state of emergency, do not often take that fact into account. Well, Mr. President, I want to tell you something this afternoon. We are here to treat with a specific problem, one that was recognized by them, one that is recognized by the heads of government in the region, one that is recognized by us. No, I am not giving way. And unless you have a point of order, all right. So, Mr. President, Mr. President, this is a serious problem. It is the problem has been outlined to us at the national level by our police service, by our intelligence agencies, by heads of government who have at their disposal in CARICOM impacts a regional intelligence body. Now, we say on this side that efforts and resources must be proportionately allocated to the areas in which there is literal warfare being waged by rival gangs. I spoke of situations where you have a half of a street belonging to one gang in my piloting of the bill, another half belonging to someone else. And if you are unfortunate enough to stray across to one side of the street, that's it for you. Now, gang-related crime has affected law-abiding citizens in the communities that my friends speak of. Exactly. I know because I was born in Bella Road, which is supposed to be the headquarters of SIX. Okay? I was born in Bella Road. I grew up in Bella Road in Belmont. Now, there have been, and when I say I grew up in Bella Road in Belmont, I had, without going into details, and this is not, as a man, I don't wish to speak about it. As a child, I had someone who would help me, a babysitter. And that woman found herself in my office as Attorney General to ask me if I could do something. I couldn't, about sending army into her area where she lives in Belmont, because she says she cannot sleep at night. This is a woman who took care of me as a child. She's an elderly person. There are good and decent persons in these communities who live under panic every night. What we propose in this bill is an approach that stamps out the gangs institutionally, eliminates the socio-economic dysfunction that has enabled their existence. The measures are outlined in the bill. I outlined them in piloting the bill. They've been spoken to at length over the past 4 days. While I was in Barbados, as I went to the Attorney General's round table, and we spoke on crime and also on gang-related crime. I interfaced with my colleagues from Jamaica up to this morning, and they say that the impact of this legislation, the ZOSOs, has been significant. They say so. But they also say that it has to be carefully calibrated well thought out, meticulously deployed, finely balanced, and well resourced, because that community engagement bit of it has to be well resourced. You are talking about once you establish a police, and I've heard my friends talking about the army and the army being trained to fight wars. There have been no wars in Trinidad ever. In 1970 and 1990, the army was called upon to put down an insurrection. So what that means is that, taking 1990, for 35 years, the army has functioned as a constabulary force. All that they do is to support the Trinidad and Tobago Police Service. And it is not nonsense, it is arrant nonsense to say that all of a sudden, these persons who are trained to do what armies are trained to do, but who have been for generations. So you have people who have joined the army, left the army, their kids have come in, left the army, who have only had experience with the army as a constabulary force. There's an acronym for JAPS, Joint Army Police Patrols. That's it. But my friends opposite are hell-bent on opposing for the sake of opposition. The idea that the army should help the police. Well, it is a force multiplier, and they are needed to assist the police. This is not a new problem. We've had JAPs, Joint Army Police Patrols, for decades, as I've said. Now, if I could just go back, and this is because of the criticism that I did not speak to statistical data. I don't like to quote that gentleman who, if somebody, let me take myself out of it. I don't like to quote a particular prime minister. I don't think he's deserving, worthy of being quoted in this house. But I'll make this exception just this time. He said of this law, the draft law has the potential, these are his words, Now, he speaks out of, so he say, you're a dog today. I received that. I wear it as a badge of honor. It didn't matter to me. And then some other time he'll say something else when it suits him. But he said these words: the draft law has the potential to deepen and to sustain on the ground anti-crime activities of the protective services in areas of high criminality. Now, that's the same bill, basically, that we're dealing with here today. But he lacked the courage, as he always does. He failed to follow through on it. And if he did not lack the courage, he lacked the incentive, because he liked to play golf. He used to be found on the 9th hole of wherever in Tobago. In a report by the TTPS, Trinidad and Tobago Gang Review 2016-2017, the Criminal Gang and Intelligence Unit of the TTPS, which he referred to, said these words: during the period 1st January 2016 to June 2017, the number of gangs and its members existing in Trinidad and Tobago has grown exponentially. He said that almost 10 years ago. What did he do? Nothing. Now, he had the data, he had the law, he had the resources, he was in power, and one place that he was not, he may have been elsewhere, as I say, the ninth hole, he was not here, and he was not piloting this bill. That's what he was not doing. Mr. President, I said last week that this government would never allow the country to slide back into the state of anarchy in which we found it in 9 months ago. We will not, I said, allow the hypocrisy of those on the other side to distract us. Now, if I could just move quickly to speak to the contributions of the members. Okay. Senator Arawi. Well, Senator Arawi was an Attorney General. I have looked at the legislation that he had before him, consulted the technocrat who is here, who drafted the bill, and I cannot for the life of me understand why. I take it that you learned something in your constitutional law classes. And if you did,
he was there long enough.
If you did, you would know that there's a difference between a constitutional amendment, which is governed by Section 54 of the Constitution, and a bill that is one that does not amend the Constitution, but might conflict with the entrenched rights. One has a usually would have a 2/3 majority, the other would normally have a 3/5 majority. The Constitution tells you which is what. The constitutional clause for drafting what I would call a Section 54 bill, a constitutional amendment, would read something like this. This act shall be read as altering the Constitution. Why? Because it's an act that alters / amends the Constitution. But the constitutional clause for a Section 13 bill, one that does not amend the Constitution, but might conflict with a protected right, would read something like this. This act shall have effect, even though inconsistent with 4 and 5, that's the entrenched rights of the Constitution. Now, if you look at the bill before us, the preamble, Section 13 may expressly declare, shall have effect even though so and so, whereas it is expedient to do so and so. This act shall have effect even though inconsistent with sections 4 and 5. It is not an amendment to the Constitution. And I would be happy to have a refresher course for Senator Arawi at the University of the West Indies on this at any time. So what I have to say on that, Senator Arawi, is that we on this side will not follow you down the rabbit hole that you have borrowed, squirrel yourself away in. The bill is, the Section 13 preamble and constitutional clause is properly before us. and properly in the bill. I reject it. There will be no amendment. Now, on the other questions, now that we've dealt with the easy bit first, there was some discussion about a bare majority. And, again?
And 454.
I think that should be enough. I hope I'm not. Good. That's the spirit. So there was some discussion about bare majority. And I just want us to go back to the Jamaican bill, which they unabashedly said, we copy it. That's what they said. Right. We copied it.
But nobody doesn't listen to
Well, you know what? The Jamaican bill, a sealed copy, which was provided to me by my technocrat, shows that there was no constitutional preamble, no parliamentary certificate. What does that indicate? The bill was passed with no special majority. No special majority was thought to be required. Now, having said all of that, I hasten to add that their constitutional provisions are slightly different from ours. They have a referendum and so on and so forth. But the point is that it's a simple majority bill, especially since Surat and Suraj. Mr. President, if this government was anything but a decent government, and bearing in mind all that has happened here today, and the fact that constitutional majority is by no means assured, do you know what could be done and has been done in the past by some of my friends on the other side? I can amend this bill right now, take out the constitutional clause, and pass this bill with a simple majority. I will not do that. That's not how. That is not how we do business on this. Now, I just want to deal with Surat and Suraj and the points that make the legislative safeguards in the bill proportionate. One, there's a limitation on the duration with respect to which you can label a place as zone. Two, there is parliamentary oversight for an extension of a zone. Three, there's judicial oversight. You grab someone, it's not like a state of emergency where the writ of habeas corpus does not run in a state of emergency. You get someone in a state of emergency, what do? The Minister of National Homeland Security writes on a piece of paper, you are detained. That's a PDO. That's what it's called. And you know what? That person is detained. And his recourse is a tribunal established by the Chief Justice. This bill provides for judicial oversight. You have a magistrate, you have a judge. Then there's a time period on the duration for which you can hold someone in custody. The rights of prisoners are respected. Rights of counsel, family visits. I'm told, although I have not seen this myself, that you have a right to a person of your feet. The grounds of arrest must be in accordance with the prevailing law. The joint command provision, which requires that The Joint Command shall submit a written report to the NSC every 30 days. Parliamentary approval, parliamentary accountability, parliamentary review every 3 years. None of these is available in a state of emergency. All of these are indicators of the fact that the bill is proportional and that it meets the very real crisis outlined by heads of government, by the former Prime Minister, by the former Attorney General, and by us on this side. Now, the question is, what happens after an arrest in a zone? Well, the bill does not seek to deprive a suspect of his rights. As I've said, he's entitled to the normal rights that persons have under the Constitution, statute, and the common law, and the writ of habeas corpus obviously runs. I'm not going to speak to Senator Drayton's comments, although they were supportive in the main of the legislation. Now, I turn to the questions that I highlighted at the beginning when I said that these are the matters that I'll try to focus on. Why no sunset clause? We say the bill does not require a sunset clause because Clause 28 already provides for a review by way of a parliamentary committee. Further, the bill is not a short-term measure to address criminality and escalating levels of violence in the society. There's a lot of confusion that this is a bill that is, as my friends have done a remarkable job of selling to the people of Trinidad and Tobago, that this is legislation that will put an end to life as we know it. When we know, they quoted from a statement made by the Honourable Prime Minister in 2011, where she, the Honourable Prime Minister, saw the need to have special measures for special areas. In 2017, it was their Prime Minister. Now it is us. This is something that is required, and we have the courage to bring it today. Now, there's another reason why there's no sunset clause on it, and this has to do with the soft part of the legislation, the Social Transformation Committee. Once that starts, I'm told by my colleagues in Jamaica that is actually a very powerful tool in terms of getting the communities to buy in to the fact that life can be better without the gangs. They are able to access services, they are able to come out of their houses, they are able to do things that they would not normally do when crossing the street is hazardous to their health and possibly might mean the end of their life. If you give people in these communities job opportunities, if you give them, if their problems are related to land tenure, their problems sometimes are related to health and so on. You want to have institutions which are inside of these communities which live. So this is really, as the long title to the bill suggests, something that is designed to deal with the gang issue at its roots. Now, I'm going to ignore Senator Obika, Senator John Baines, and so on. there are some suggestions by Senator De La Bastille was concerned on consultation before the bill becomes law. Unfortunately, we cannot, given the nature of the threat that we now face, treat with any, it would be akin with respect to us looking on while Rome is burning. We know that this legislation works. We have the example of our partners as they did. What we can do and what I can commit to doing is to engage in a process afterwards to look at how as we did with AJIPA, this is not something that is new. When you pass legislation like that, urgent legislation, you look to see, okay, is it working here? Are there deficiencies here? How can we fix this? How can we improve this? But we cannot at this time delay this because we are committed to treating with the gang problem, which this has, we have now seen huge benefits from the state of emergency with respect to gangs. We are taking the opportunity now to press home that advantage. And Mr. President, I want to tell everyone in this Senate this afternoon, we are not going back. I just want to use 3 more words. No matter what. Now, Senator Vera, I trust that you would allow me to move on over your contribution, which I thought was interesting and progressive, on the use of the military. I think I've dealt with that. Senator McNeish, Senator Atz, well, the training of security forces deployed in the zone, that is something which we also consider to be a long-term measure. And Senator Lewis, the issue of executive overreach, we don't agree on that point. It is, as I say, it seems to us, and perhaps I'm not sure if I am being overly defensive, but this is the legislation which passed in Jamaica, which our friends opposite mooted. We do not see that there is a difficulty with having the Prime Minister in council, which is actually the way a state of emergency is declared. My friend would know. The National Security Council is the one that does the deed. The president simply signs on the dotted line. Now, I'm going to ignore completely this gentleman, Senator Obika.
Please ignore him.
And I am going to just deal with one point made by Senator Jones on rampant crime. I think that I accept that it's not something that you see in legislation every day, but it is an English word, it has an English meaning, and we think that it is appropriate and not ambiguous. Mr. President, with those words, I beg to move. I have to say, though, and that we have carefully considered the proposals made by the independent bench. Many of them are deserving, careful, and thoughtful, and should be weighed against the urgency of the moment. But this is no ordinary piece of legislation. We need to get this on the books right away. The government is unable to accept amendments to the legislation. this afternoon. We do, however, commit to a continuous process of engagement with the independents in particular, and we'd like to discuss with them a structure in which that could take place. Mr. President, with those few words, I beg to move.
Honourable Senators, the question is that a bill entitled An Act to Provide for Special Measures for Upholding and Preserving the Rule of Law, Public Order, Citizen Security, and Public Safety within certain geographically defined areas of Trinidad and Tobago, and for other related matters, be now read a second time. Those in favor say aye. Aye. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Titled, An Act to Provide for Special Measures for Upholding and Preserving the Rule of Law, Public Order, Citizen Security, and Public Safety within certain geographically defined areas of Trinidad and Tobago, and for other related matters.
Honourable Senators, I would like to propose that before we get into the committee of the whole Senate, that we take our tea break at this time. So when we return, we shall proceed uninterruptedly. So at this time, the sitting is suspended until 6 p.m.